Hey folks, I'm Roger P. Foley, and I'm over here in Polk County, where things are hard. I had a young man who was homeless and was transferred to another jurisdiction. Now that jurisdiction, well, when he got there, he had a place, but he didn't have a place for very long. Told his probation officer, I'm homeless, I don't have a place to stay. He finds somewhere else to stay temporarily, but that's only for about a month. And then he tells probation, look, I really have no place to stay. I'm out in the woods. It's snowing. I don't have shelter. Is there any way you can transfer me to another jurisdiction, because I have a friend that's allowing me to stay with him? Florida tells the other jurisdiction, well, Florida tells the client, well, you got to talk to the jurisdiction because your probation's been transferred there. That jurisdiction tells the client, well, you got to talk to Florida because your probation originates in Florida. No one takes the responsibility. He ultimately gets violated for being homeless. I take over the case. I make the argument to the state. I provide case law. Case law shows that being homeless by itself is not sufficient to violate probation. It's got to be a willful violation. They say, yeah, sorry, we don't really agree with that. You can have a final VOP hearing, but it's going to be at least a month, maybe 2 months, maybe longer, and your client sits in custody. Well, of course, my client wants to get out of custody. Client has no criminal history as a juvenile or as an adult other than this one case. I take a chance. They have what's called a VOP court here. Very unusual, but I say, Judge, the state's asking for 30 days time served, and I'm asking for a withhold of adjudication. And the court says, I don't know if I can do that. I go, you can do it, Judge, if it's a special condition of probation. For instance, he's on probation, but it's a special condition that upon completing the 30 days of jail, the case is closed. We had to plea open. I don't like to plea open. I don't know. And man, I'm taking a risk in Polk County, right, where they're super tough on crime, where police do their own thing. That officer you see, the sheriff's always putting the videos out, but my goodness, watch some of the videos of what his troopers do to people. They beat the crap out of him. In this case, my client got the crap beat out of him, and if he allows me to share it online, I will share it. Had another case, same thing. Yeah, man, it's, hey, we're tough, but we're tough and we're beating the hell out of people, and there's really no repercussions. That's a side note. Anyway, open plea to the judge going, please, God, please do the right thing, and please give this young person the benefit of the doubt. I just proffered. I did my research. I know the facts of the case. Even probation themselves said, hey, we don't know if it's a violation. We had to check with Interstate Compact, and they said we had to violate because they canceled probation. All that shared with the judge. Judge goes, okay, I don't know what I'm going to do. I don't know what I'm going to do. I don't know what I'm going to do. And then he goes, okay, I'm going to do exactly what the state wants me to do. Time served. Instead of 30 days, it was 28 days, but the reality is you would have got 5 days credit for time served anyway. So, man, you go to the battle and you prepare. I didn't expect that the judge didn't know something, and I should have. And my mistake was, if he thinks, and another attorney said, man, he goes, as soon as he said, I don't think the court can do that, he goes, I thought you had a problem. And honest critique from a fellow attorney in that area. And he said, yeah, I don't think he knew if he could do it, so was he going to take the chance if he couldn't do it? Me, I'd take the benefit of the doubt as a judge and realize that a young man's being violated for being homeless. That's not a willful violation. But the problem is he would have stayed in another 60 or 90 days to wait for a final VOP hearing. I presented the case law. Prosecutor's a nice guy, but nah, we don't do that. We don't do that. Nah, we can't do that. Nah, we can't. Everything was no. Again, nice guy, professional, courteous, returned phone calls, returned emails, but not willing to go outside the box at all. It was just black or white. So the client got time served. The good thing is that the judge didn't hit him with 2 years, because he had two charges that ran consecutive. The judge could have given him minus the probation or whatever, and the time he could have given him a year and 6-8 months. So he didn't do that. So that's a blessing. But man, it's like going a 12-round distance and you lose. So what could I have done better? I should have brought the case law with me, that it's doable. He's like, yeah, I've never heard of anyone, judges and officers of the court, I've done it before. I've done it before. But just because you've done it before doesn't mean that it's legit, right? It just means no one appealed. I wish I would have had that case law with me. That's the only difference. Or if the judge would have allowed me, hey, Mr. Foley, why don't you take 15 minutes and see if you can find me that case law that says I can do it. So, time served. Now this young client has an adjudication on their record, and they can never seal it, they can never expunge it, and yeah, man, it just beats me up. It beats me up. We need to do better. We need to do better as a system. We need to do better as a court system. We need to do better as defense attorneys. We need to look at justice versus punishment. Sometimes justice is punishment. This was not a case that punishment, giving this young person a conviction on their record, helped them. They think that they did me a favor by giving them time served. That was no favor. Anyway, I'm attorney Roger P. Foley. See ya.